Oyez, oyez, oyez. Anyone having business before the King's Justice, the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all.
Morning. As a first order of business this morning, Justice Hennessy, I have reprinted a copy of the Chippewas of Nawash, Ontario Court of Appeal case in larger font. I'm happy to pass that up.
Thank you. Thank you very much.
And before I resumed my submissions on the appropriate bring forward rates, calculating the present value of the lost opportunity, I wanted to return briefly to a question and an exchange that we had yesterday, and that was regarding the ability of the courts to affect reconciliation in this country. And I wanted to make a few more submissions on that point with reference to the somewhat recent Supreme Court of Canada case in RV Deshotel, which is 2021 SCC 17. I think some comments from the majority of the court, majority decision written by Justice Rowe, are useful for that discussion. And I think the starting point is, of course, that the courts in this country are the guardians of the Constitution, and that includes Section 35 and the protection of Aboriginal and treaty rights. And at paragraphs 85 to 86 of the decision, Justice Rowe discussed how the courts must generously and purposively interpret Section 35(1) to further its central objective, and that being reconciliation. So of course, that's at least one area where the courts have a recognized role in the project of reconciliation in this country. And perhaps some of your comments yesterday, your questions yesterday, related to the fact that the Supreme Court in Deshotel did pick up on the statement from the Clyde River case that true reconciliation is rarely, if ever, achieved in the courtroom. And that appears at paragraph 87 of the Deshotel case. And I think it's important to recognize that what the Supreme Court is not saying is that the courts don't have any role to play or can't consider reconciliation, but simply that reconciliation cannot come from the courtroom alone. And negotiation has a crucial part to play as well. And the Supreme Court has repeated that statement on many occasions, in many cases, the importance of negotiation towards reconciliation. Your Honor made comments about the importance of negotiation in her Stage 1 decision. The Court of Appeal encouraged negotiation as well. But respectfully, negotiation has not led to a just result in this case, or the ability to restore the Crown's honor after over a century of neglect of its treaty promise. And importantly, in Deshotel, Justice Rowe also explained that at paragraph 91, that the negotiation table is not a substitute for the courtroom. Specifically, he said, the negotiation table should not be seen as a substitute for the courtroom, nor the courtroom as an alternative to the negotiating table. So of course, both processes, both litigation and negotiation, have their role to play in reconciliation. And at paragraph 92, Justice Rowe went on that it's for the parties themselves to decide how they wish to proceed. And of course, the parties are in the courtroom today. And we submit that what reconciliation requires in this case is just compensation for the past breaches and concrete directions for future implementation to set the parties up for success going forward. And of course, that is how the processes of litigation and negotiation can work together to effect reconciliation in this country. And that's what we're asking for from this court. Give us the tools to go forward and to succeed in the future so that other processes will hopefully succeed and so that we don't find ourselves back in the courtroom in 5 years' time, 10 years' time, 173 years' time. And I return to a point that I mentioned briefly yesterday, and that is we firmly believe that all Canadians and all Canadian institutions have a part to play in the project of reconciliation. And certainly this court can consider how its award, how its any remedy it considers furthers that project. And so with that, I would return to my submissions on accounting for the present value. And specifically the area where I left off yesterday is discussion of government control over the band trust accounts. And in their closing submissions, both Canada and Ontario have relied on the government's strict control over money that was held in the band trust account rates on behalf of First Nations, at least until the 1950s. And I think Ontario and Canada rely on different dates there, but we can say at least until the 1950s.
When you say relied on or referenced,
Well, both, as I read their submissions, both Ontario and Canada rely on this fact as an argument against the 60-40 approach. As I understand their arguments, they essentially say you can't use the 60-40 approach because the First Nations could not have used their annuity monies in the ways proposed by the plaintiffs because the government exercised this strict control over money in the band trust account rates until at least the 1950s. And therefore, essentially, the government never would have allowed investments in the nature that the plaintiffs are suggesting. And so it's not a true way to account for the lost opportunity in this case.
I may have asked this already, and if I have, I'm sorry, but can you remind me the genesis of band trust accounts and how it was? Is it an Indian Act provision that requires the monies coming to the bands to be put into band trust accounts?
It does relate to the Indian Act and the Indian Act provisions, and Dr. Angel's report refers to various provisions of the Indian Act and the control of the government, the ability of the government to disperse funds held on behalf of First Nations. And you may recall there was detailed cross-examination of Dr. Angel as well on the ability of the government to spend money over the objections of the First Nations and the provisions of the Indian Act that allowed the government to do that. There was also discussion in this trial about the conversion to. This is what he said. Yeah, so hopefully Mr. Schachter has pointed out, starting at paragraph 70 of Dr. Angel's report, that's where he discusses, I'll just read briefly, from 1860 onwards, a series of statutes and statutory amendments gave officials working for the province of Canada and later the government of Canada control over the working for the province of Canada and later the government of Canada control over the management of monies held on behalf of First Nations.
So pre-Confederation.
Pre-Confederation. So I believe it started with the predecessors of the Indian Act, and then the provisions were carried through in the Indian Act, and Dr. Angel goes through various amendments to the Indian Act. And of course, there was also discussion at the trial as well regarding the investments that the government made on behalf of First Nations, and how around, I believe it was around the 1860s, the band trust account system was set up in order to provide set prescribed interest rates on the money held in the band trust accounts, rather than the government holding actual investment shares, bonds on behalf of the First Nations.
Thank you.
But the crux of our argument in this regard is that the submissions of Canada and Ontario regarding the government's strict control over Indian money in the band trust account rates are misplaced, because government control over the band trust accounts is irrelevant to the question of what the beneficiaries could have done with augmented annuity funds. And that's because annuity money was always paid out to the beneficiaries to do with as they saw fit. And as I read their submissions, I did not see either Crown defendant present any evidence or even really make the argument that augmented annuity money would have been considered Indian monies or would have met the definition of Indian monies under the Indian Act, and therefore would have been subject to this regime of government control that they refer to. And in fact, the uncontradicted evidence from the trial is that the annuities were always paid out to beneficiaries. They could spend it as they saw fit. There was no evidence of annuity money after it was due being retained in the band trust accounts, or, for example, flowing from the treaty-wide accounts. You'll remember Dr. Angel spoke about the treaty-wide annuity accounts. There was no evidence of the annuity money going from that account into a band-specific trust account to be held on behalf of the band. So, for example, going from the Robinson Superior treaty-wide account to Mishippicotten First Nations band trust account, for example, and then the annuity money for Mishippicotten being held in the band trust account on behalf of the band. And so,
can you just remind me, was the money that was not distributed, for instance, should a family not arrive on treaty day and the money was not distributed to that particular family, was that money was put in the BTA or no, or was held back by the?
That money would have been retained in the treaty-wide account. I think perhaps it's a little bit unclear whether we should refer to the treaty-wide accounts as band trust accounts, but they functioned in a similar manner, I think, and the rate applied to monies held in the interest accounts of the treaty-wide accounts, the band trust account rate was applied to there. So Dr. Angel did discuss how there might be, I believe he referred to it, his exact words are small amounts. And I believe he referred to them as refunds as well, or at least in the period when Robinson Superior treaty annuities were paid through the Hudson's Bay Company. It would be refunds, is how Dr. Angel referred to them, would be retained in the treaty-wide account, but those were relatively small amounts, very small amounts compared to the treaties overall. Certainly the general practice was that in the year in which they were due, the annuities flowed out of the treaty-wide accounts to Indian agents to be dispersed to the beneficiaries. They were then put in the hands of beneficiaries who could do with the money as they saw fit.
Thank you.
And it was both Dr. Angel, who is a witness for Ontario, and Professor Booth, a witness for Canada, who agreed that there weren't any restrictions on annuity money and that beneficiaries could spend that annuity money as they wished. I'm not going to take you. Okay, my apologies. I'm not going to take you to those specific sections, take you through the sections of the transcript, but I note that the discussion from Dr. Angel, we've included at page 142 of our oral compendium. And the discussion from Professor Booth is at page 145 of our compendium. And their evidence was consistent on this point. And indeed, and elsewhere in their submissions, the defendants seem to accept and acknowledge this fact in arguing that the band trust account rate is inappropriate as a bring forward rate because the money was not retained in the band trust accounts. And so the fact that other money, other types of monies, other types of funds that were held by the government on behalf of bands, such as money for the sale of timber rights on reserves. The fact that that money was subject to strict government control is really irrelevant to what beneficiaries could have done or would have done with funds that were owed to them and historically always paid directly to them. And in its reply submissions, Ontario seems to suggest that because the unpaid annuities, the unpaid augmented annuities that we're discussing were a collective entitlement and were potentially significant sums of money, the Crown likely would have held onto it for the bands and exercised the same strict control that we saw with other money in the band trust accounts. That's at paragraph 130 of Ontario's reply closing submissions. They make that argument.
Let me just see if I've got that. As I understand the argument, that the annuities, the augmented annuities, had they been paid, would have been treated, would have been controlled and treated like those annuities not dispersed.
That is Ontario's argument, I believe, or would have been treated like other Indian monies that were held by the government on behalf of bands. So equivalent to funds received for sale of reserve land or sale of timber rights on reserve. Those were the common examples that Dr. Angel spoke about of the money that was held in band trust accounts on behalf of the band, and to which this regime of strict control that he spoke about applied.
Is it fair to use the short form proceeds monies when one talks about the other monies that ended, the type of monies that ended up in the band trust accounts? Proceeds from sale of timber or sale of reserve land?
Those are certainly I think the most common examples that we saw. I'd be hesitant to describe that as that it was exclusively those sorts of funds. I mean, certainly, and I'll get to this in a bit as well, but there were other treaties that had other provisions that referred specifically to money being held by the government on behalf of the band or invested by the government on the band's behalf. So it could refer to, I believe, other sorts of funds, but certainly proceeds from land sales on reserve, timber sales, mineral rights on reserves, potentially. I think those were the most common examples that we saw, certainly.
Thank you.
Okay. And our response is that Ontario's argument is pure speculation. There's no evidence to support that this is what would have occurred. And in fact, it would have been entirely inconsistent, not consistent with the Crown's historical conduct regarding the annuities that were due, which is that they were paid out when they were due.
Speculation or aspiration?
I'll call it speculation. And our other response is that such conduct on behalf of the Crown to retain the augmented annuity money in the band trust account and hold it on behalf of the First Nations may very well itself have been a breach of the treaty and the duty of diligent implementation. And for this point, I would like to direct the court back to the text of the treaty itself and the text of the annuity clause. If the court still has the oral closing submissions compendium of red rock and white sand. It's contained at tab 3. If the court doesn't have it, I think the court is very well familiar with the language of the Robinson Superior Treaty. And I'm only referring briefly to a particular provision, which is that in the annuity clause of the treaty states the same to be paid and delivered to the said chiefs and their tribes at a convenient season of each summer, not later than the first day of August. And as this court analyzed extensively in the stage 1 reasons and decision, that the only restriction was on the payment to be made to individuals. But the text of the treaty is quite clear that the obligation for the payment of annuities is to the chiefs and their tribes. And this is unlike other treaties, specifically the pre-1850 Upper Canada treaties, some of which did contain provisions for funds to be invested by the Crown for the benefit of the band. That's not what the Robinson Superior Treaty says. It says to be paid to the chiefs and their tribes. So Ontario's suggestion that the collective annuities may have been retained by the federal government in the band trust accounts may very well have been a breach of this treaty term. And so Ontario cannot argue that the bring forward rate or the present value of the lost opportunity should be lower because the government may well have breached a different term of the treaty.
Should be lower than the BTA.
Should be lower than, we would say, the 60-40 approach. Because the Ontario's argument.
You're also arguing it should be lower than the BTA rate.
They do argue lower than the BTA rate as well. But they've employed this argument of the strict control over the BTAs to say, well, this court can't find that the bands, had they received the money, would have invested them in accordance with the 60-40 approach, or we would even say would have used the funds for the social capital investments or human capital investments that I spoke about yesterday, because the government wouldn't have allowed that. It would have retained this money in the band trust account rates, and it would have exercised strict control over that money. While Ontario can't point to a other potential breach of the treaty to answer the 60-40 approach.
Or intention to. It's not that they did it. They can't point to an alternative available to them that would, that you say would have constituted a breach of treaty.
I think that's a good way of putting it, Your Honor.
Go ahead.
And next, I want to briefly address another one of Ontario's criticisms of the 60-40 approach. And in their closing submissions, this is the original closing submissions, at paragraph 539, they claim that 60% equities is too high a percentage to use, because even as early as 1961, only 11% of trustee pension fund assets were held as equities. So they say you can't use the 60-40 approach because the evidence of Professor Bodway was that even in 1961, for trustee pension funds, they only had 11% of assets in equities. And this statistic is actually somewhat misleading, So I followed the path to the support for the statistic that Ontario relies on. So just if,
And did that statistic come from Professor Bodway's evidence?
so it did, and I'm going to provide the path so that if Your Honor wants to follow the same path I did, you can. And that is that Ontario cites to slide 63 of Professor Bodway's demonstratives, which is exhibit 74. That slide in turn cites to paragraph 150 of Professor Bodway and Professor Smart's present value report. And the reference provided in the report for support for the statistic is tables put out by Statistics Canada regarding balance sheets of trustee pension plans. And if Your Honor is interested in looking at that supporting data, it is contained in the Joint Book of Documents, Exhibit 1-5593 to Exhibit 1-5596. So that's where they're contained in the Joint Book of Documents. And if you look at these tables from Statistics Canada, they don't actually neatly break down pension plan portfolios into government bonds or risk-free assets on one side and equities on the other. Rather, they provide information on the holdings of trustee pensions by broad asset type, not necessarily by riskiness. So it's broken down by different asset types held by trustee pension plans. And what Professor Bodway appears to have done to arrive at the statistic is to take the total percentage listed as shares and say that's 11% in 1961. But to be clear, the other 89% are not risk-free assets like the long-term government bonds and actually contain various risky assets. So there is a category for bonds, but that would include both government bonds and corporate bonds being a far riskier asset than government bonds. There's also a category for foreign investment, which would include bonds of foreign countries, potentially a very different risk profile than long-term government bonds, long-term government Canadian bonds, foreign equities and all sorts of other foreign investments, and also investments in loans, mortgages, real estate. The reason why I bring this all up is simply to point out that it's somewhat misleading to point to these statistics and claim that until the 1960s, trustee pension plans invested 89% of their assets into risk-free investments, or only 11% were invested in risky assets such as equities.
That until what, the 50s?
Until the 1960s. Ontario and Professor Bodway used the statistic for 1961 they rely on. And my point is simply that the risk profile is much more diversified. And so having discussed the 60-40 approach, which is the approach that the plaintiffs urge Your Honor to use, I now want to discuss some of the other approaches that have been presented to you and explain why they are inappropriate. And I'll start briefly with the long-term bond rate. And we submit that the justification for using the long-term government bond rate improperly focuses entirely on the perspective of the Crown. And it was the evidence of Professor Smart that provided the justification for using the long-term bond rate. We've included excerpts of Professor Smart's evidence on this point, starting at page 148 of our oral compendium. And perhaps it might be easier if I simply summarize the evidence, but it is contained at page 148.
Thank you.
And Professor Smart does claim that you can think about it from either perspective. That's how he starts. You can look at it from the Crown perspective or from the annuitant's perspective, but I want to break that down a little bit more. The justification, considering it from the Crown's perspective, Your Honor might remember, is that it essentially measures the benefit to the government of having wrongfully retained the money. The argument, as I understand it, is that because the government didn't pay out the annuities when they were due, it was able to retain those funds and use it for other purposes. And that had the government actually paid out the annuities when they were due and in the amount that was due, and they wished to maintain equal levels of funding in all other areas as what they historically did, in order to account for the shortfall, they would have had to have issued more bonds and they would have paid the long-term bond rate on those bonds. So in that sense, it measures the benefit to the government of having not paid the annuities.
Let's see if I get this. The Crown, according to your understanding of it, the Crown says had they retained the money had they retained it, they would have earned long-term bond rates. Had they dispersed it, or had they had to disperse it, they would have had to borrow.
So I think that the second part is precisely accurate.
Okay.
The first part, of course, the government did retain the money. The government didn't pay the augmented annuities when they were due.
But they don't set that up as a baseline for this argument.
Well, the baseline is that the government, in actuality, historically, what actually happened is that the government did not pay the augmented annuities when they were due. And so they were able to use the money that otherwise would have been paid to the beneficiaries for other purposes, whatever the government wished to do with it. And then in the counterfactual world, in which they had actually paid the augmented annuities that were due when they were due, if the government wished to maintain all of that same spending, they would have had to borrow.
And they would have borrowed at the long term.
They would have borrowed at the long-term bond rate. And I'm sure if I have misunderstood that or misstated that, Ontario will correct me in their submissions. But that's the justification from the Crown side. It measures the benefit to the Crown of having wrongfully retained the money. But for the Anishinaabe beneficiaries, the justification that Professor Smart provided in his testimony and Professors Bodway and Smart provided in their reports is that, well, the Anishinaabe could have used the funds to buy bonds. And as we discussed at length yesterday in my submissions, and discussed somewhat earlier this morning as well regarding the government control over the annuity funds, the beneficiaries could have done many things. They were not restricted to purchasing long-term bonds with the annuity money that they received. They could have made many other investments. And I went through the evidence at the end of the day yesterday about our submissions about what the evidence actually shows about what they would have done with the money. And so that's why we say that the justification for the use of the long-term bond rate is backwards. The compensation analysis in this case, and this is regardless of whether Your Honor considers it from the perspective of equitable compensation or common law damages, in either respect, the compensation analysis focuses on accounting for the loss to the beneficiaries. The goal in compensation is to restore the plaintiffs as closely as possible to the position they would have been in but for the breach. And the long-term government bond rate does not do that. Instead, it focuses, we would say almost exclusively, on restoring the Crown to the position it would have been in had it not breached its promise. And that's why we say it's backwards. And unless Your Honor has any more questions about the long-term bond rate, I would move on to the last model that was suggested, which is the Booth and Kersner approach. And we submit that the Booth and Kersner model presented by Witnesses for Canada suffers from practical, methodological, legal, and ethical issues, and for that reason should not be adopted. It has been soundly, and we would say properly, rejected by every court and every tribunal that has considered it, and this court ought to do the same. And as a result of the problems with the model, it should not form any part of this court's bring forward analysis, and that's whether it's presented as being adopted on its own or being presented as one pole of a scale in order to reach a midpoint of an appropriate bring forward rate, which is how I understand the use for which Canada has put it in its closing submissions. As I understand it, Canada is not urging this court to adopt the Booth and Kersner model wholesale, but rather says it's one appropriate method. And when you look at various other appropriate methods and you kind of take the average of them or look at the midpoint of various appropriate methods, you get to essentially 5%, essentially the long-term government bond rate. But our submission is whether it's the court is being asked to use the model itself or being used to consider the model on some other scale shouldn't be considered whatsoever. And the first set of issues concern the data that was used to build the model in this case. And I don't want to dwell on these issues. We've set them out in our written submissions, in the original written submissions of the group of 7. So I don't want to dwell on them, but just as a brief reminder for the court, Professors Booth and Kersner built their model from only looking at 16 of the 34 both RST and RHT bands. Only 6 of those 16 bands were RST bands. So in fact, the majority were RHT bands. They only looked at spending up till 1956, assuming that spending after 1856 from the band trust accounts would have been identical. Sorry, 1950. My friend has corrected me. It is 1956. My apologies.
Just 100 years.
Yes. So they looked to 1956. They didn't only look to 1856. So they looked up to 1956 and then assumed that all spending after 1956 was identical to 1956, where of course we actually have good reason to believe that spending patterns would have changed significantly after 1956 in the band trust accounts. And that goes to the point that we were just discussing about the easing of government control over these accounts after the 1950s. They only looked at the revenue accounts and not the capital accounts. And the work that was performed by Ernst & Young to create the classification of the various spending, we would submit was quite questionable. And we've set that out in our written submissions. I believe Mr. Schachter spoke about that briefly as well. But in short, the practical issues raise real questions about whether Professors Booth and Kersner really collected and looked at a representative sample of spending patterns with which to build their model. But beyond the practical issues, there are much deeper issues with the model. One of the main ones being that it's founded on what Professor Kersner referred to as the proportionality assumption. And that's the assumption that if bands received more funds as annuities, they would have spent that additional money in exactly the same proportions as the money that they did have in the past and historically spent. And Mr. Schachter, again, he spoke about this in his submissions, why the proportionality assumption is flawed. I don't want to repeat his submissions, but the crux is that a significant influx of funds, such as unpaid augmented annuities, likely would have changed the band's spending patterns.
But as I said to Mr. Schachter, but you're looking at the difference between 93% and something else. Because the pattern was, as I recall, 93% saved, not spent.
So that's the analysis that we say results from considering accounts that Professor Booth and Kersner didn't actually consider in building their model. They had the saving rate much lower because they only looked at the revenue accounts. So
the 93% does not come from Booth and Kersner.
I believe they admitted to it in cross-examination when they were taken to look at the capital account and look at the revenue account. But on the model as they initially built it, they had a much lower savings rate. But the next flaw that I want to discuss is the inherent injustice that is built directly into the model. And that is because the model is based off the historic spending patterns of First Nations. And we know, and I believe both Professor Kersner and Professor Booth admitted in their testimony, that wealthy communities and poor communities will spend their money differently. Historically, wealthy communities will tend to save more, and poorer communities will tend to spend more of their funds on consumption goods. And so when you build a model that assigns different interest rates, different bring forward rates based on the historical spending of the bands, what you get is a higher average rate for a wealthy band that has saved more, and a lower interest rate for a historically poorer band that was forced to expend more of the funds that it had.
For consumption.
For consumption, which attracts the lowest rate of return under the Booth and Kersner model. And so if you take the model to its logical conclusion, poorer bands would receive less compensation for the exact same breach.
Well, if you were doing it band by band on the spending patterns.
So you can look at it different ways. One is if they had broken it down band by band in this case, they would say that a wealthier band, I'm not going to provide examples of which ones might be wealthier, which ones might be poorer, but if they had broken it down band by band, they would say that different bands would receive different amounts of compensation for the exact same amount of historical unpaid annuities.
You're saying that's where the model leads to.
That's the logical conclusion of the model. They only applied it on an average basis in this case, kind of looking at all of the RST and RHT bands together. But the way that the model works, if it's adopted, is that different First Nations receive different amounts of compensation for the same breach.
Because the compensation would have been based
on historical spending patterns. And the issues with the model became evident through the testimony of its proponents, and particularly through the testimony of Professor Booth. And we've included various excerpts of his testimony in our oral compendium, starting at page 163. But to highlight some of it, Professor Booth claimed that he's pointed out to every court where he's testified about the model that it has, quote, unfair implications. And those are the implications that we were just discussing. Not only did Professor Booth admit that it has these unfair implications, he claims, well, I've told every single court that I've presented the model to that it has these unfair implications, including this court. He claimed that he himself has ethical concerns with the model. And I think tellingly in an exchange and cross-examination, he tried to claim that the model wasn't even his model. It was being referred to in cross-examination as your model, the Booth and Kersner model. And he said, well, stop calling it our model. It's not our model. He said, you know, we're just applying the decision in Whitefish Lake. Don't call it our model. And ultimately, he admitted that there are problems with the model. And I do want to take you specifically to that portion of his cross-examination, which I thought was quite illuminating, which we've included at page 168 of the oral compendium, which is page 4060 of the transcripts. And you'll see at line 16, again, Professor Booth mentions that he has moral problems with the implications of the model. And then he goes on. So if you're telling me that there is some problems in the approach, I 100% agree with you. And so if the proponents of the model are readily admitting to the problems of the approach, we would submit it's inappropriate for this court to adopt it. And finally, were this court to reject the Booth and Kersner model, as we urge you to, the court will be in good company. And that's because, as I mentioned, every time the model has been presented to a court or to the specific claims tribunal, it has been rejected. And neither Professor Booth nor Professor Kersner could point to a single decision of either a court or tribunal that has employed it. And I would add, neither has Canada in its submissions cited any case that has adopted the model. And I wish to highlight two such decisions for your honor's consideration. The first is the Southwind case, which we have been speaking about quite a bit in terms of the Supreme Court's decision on and what the Supreme Court had to say about equitable compensation and fiduciary duty. But as the court may recall, the case involved compensation for flooded reserve land for hydroelectricity. And at the federal court level in that case, there was an issue of the appropriate bring forward rate, much as there is in this case. And Justice Zinn, on behalf of the federal court, was presented with the Booth and Kersner model. I believe both Professor Booth and Professor Kersner were qualified as experts and testified in that case. And Justice Zinn rejected their model. And I want to highlight some of the reasons that Justice Zinn provided for why he found that the model was inappropriate. Firstly, he found it needlessly complicated, time-consuming, and expensive. It's noted at paragraph 465 of the federal court's decision in Southwind. We've included excerpts of it in the compendium at tab 39.
Tab 39.
Tab 39 of the oral compendium, starting at page 170.
Thank you.
And paragraph 465 is found on page 172. I just summarized it. Justice Zinn rejected that spending on lost consumption should be either ignored or discounted. It's at paragraph 485. And of course, that's what Professors Kersner and Booth propose in this case. Spending compensation for past consumption spending should be discounted.
And where is paragraph 485? Oh, next page.
485 should be at page 174
Thank you.
of the oral compendium. And importantly, and another reason why I believe Justice Zinn's analysis in the Southwind case is quite helpful is because Professor Booth specifically, and Professor Kersner as well, spoke about how their model is simply an application of the Ontario Court of Appeals decision and its comments in the Whitefish Lake decision, and the need to account for, quote, realistic contingencies that Justice Laskin mentioned in that case. That was a quite constant refrain from Professor Booth in cross-examination. We're just applying Whitefish Lake. That's what we're doing. That's what Justice Laskin told us to do. And Justice Zinn in the Southwind case was actually quite critical of that argument, that the approach was simply an application of Whitefish Lake. And firstly, Justice Zinn noted that Justice Laskin's comments in Whitefish Lake about these realistic contingencies and spending patterns to consider were obiter comments, because of course the Court of Appeal in Whitefish Lake did not actually undertake the analysis. They sent the case back and said, there's insufficient evidence before us here for us to do the analysis, so we'll send it back to the trial judge with some guidance. And specifically at paragraph 113 of the Whitefish Lake decision, if you look at what
whose decision?
That's the Court of Appeals decision in Whitefish Lake.
Thank you.
What Justice Laskin actually says that he's doing is providing a list of some of the evidence that might be useful and some of the considerations that might be taken into account in fixing a fair and proportionate award at the new hearing. And as Justice Zinn pointed out in Southwind, If anything sounds like obiter comments, it's that. But moreover, Justice Zinn also explained that Justice Laskin's comments in Whitefish Lake were actually based on a misreading of Guerin. And what Justice Laskin said in Whitefish Lake is we need to consider realistic contingencies, because that's what the trial judge in Guerin did, and that was endorsed by the Supreme Court in the Guerin decision. And so I want to take you to paragraph 466 of the Southwind decision, which should be at page 172 of our oral compendium. And this is Justice Zinn's analysis of the Booth and Kersner model and its apparent application of Whitefish Lake. And Justice Zinn says at paragraph 466, I am also of the view that there has been a fundamental misunderstanding in Whitefish of Justice Collier's reference to realistic contingency in Guerin FC, the federal court decision in Guerin. The contingencies that Justice Collier describes and discusses in his reasons relate to the band's land, its development or its lease options, and the other contingencies he considers relate to the investment return on the monies the band would have received from the use to which the land was put. None of the contingencies he considers relate in any way to how the band might have spent the money had it received it in the first place. With great respect to Justice Laskin, that is not a contingency, in my view, that requires consideration at law. And so what Justice Zinn is saying in Southwind is, if you really break it down and consider the support that Justice Laskin in Whitefish Lake relied on for his comment about realistic contingencies, this question of how would the band have spent the money had they received it, what were the historic spending patterns of the band, that's not a relevant consideration.
And is he also saying it's not a contingency as per Guerin?
It's not a realistic contingency as per the language of Guerin. That's absolutely right. And since we're discussing the federal court's decision in Southwind, I think it's of course necessary to point out that while aspects of Justice Zinn's decision were overturned by the Supreme Court when it heard the case, this aspect of the trial decision was actually endorsed by Justice Karakatsanis for the majority of the Supreme Court, who simply said there wasn't a detailed analysis of the issue, but Justice Karakatsanis said she had no issue with how the trial judge brought forward or calculated present values, brought forward the present value. And that's at paragraph 145 of the Supreme Court's decision in Southwind. And the other case I wish to draw to the court's attention in respect to the Booth and Kersner model is the decision of Justice Whalen on the Specific Claims Tribunal. And I will apologize for my pronunciation. I believe it's the Huayat case, Huayat First Nations. which we've included an excerpt of at tab 40 of the oral compendium, starting at page 176. And that was a case, it concerned compensation for the improvident sale of timber rights. One of the issues was the appropriate bring forward rate, the correct way to calculate the present value. Justice Whalen, for the tribunal, again rejected the Booth and Kersner model. Justice Whalen was also critical of the claim that they were just applying Whitefish Lake. Paragraph 261, Justice Whalen discussed how the Whitefish Lake decision was the product of its particular facts and legal context, and it's easy to overinterpret the decision. But I want to specifically take your honor to what Justice Whalen said at paragraph 275 of the decision, which we have starting at page 178 of the oral compendium. And Justice Whalen says at paragraph 275, I must say, however, that the approach used here leads to great expenditure of time and money. It is very complicated. I am concerned that it also complicates the specific claims resolution process and makes First Nations access to justice more difficult. I doubt that Justice Laskin foresaw the process that would unfold in the present case and that may be repeated in other cases. So Justice Whalen's concern, and it's a concern that's repeated by Justice Zinn in Southwind as well, is that if in every case involving historical losses, the First Nations are required to bring forward evidence of their historical spending patterns and break it down into different categories and assign different interest rates to the various categories and bring it forward to present value. That's a time-consuming process. It's an expensive process. It will require extensive expert evidence, and that's actually an impediment to access to justice for First Nations. And I would submit that Justice Whalen's comments about his concern about the process on the specific claims resolution process apply equally to the process in the courts. And finally, Justice Whalen did provide a detailed discussion of why he should not discount compensation to account for lost consumption spending. And it includes some of the points that have already been discussed and that we discuss in our written submissions. I'm not going to take the court through it, but I would commend to the court paragraphs 312 to 321 of the decision, and that's where Justice Whalen goes through the issue of consumption spending. We've included that starting at page 180 of the oral compendium. So it is included in the oral compendium. I don't think it's necessary to go through it paragraph by paragraph, but I would commend those paragraphs to your honor.
Thank you.
And ultimately, we submit that this court should not be the very first court or tribunal to adopt the Booth and Kersner model. And so those are my submissions on accounting for the present value of the loss, the bring forward rates. Unless the court has any further questions, I will move on to my submissions about the holdback for Name Gusa Sagagan. I believe I have time to cover it before the morning break.
Thank you.
And in these submissions, I may refer to the plaintiff, the Name-Gusa-Sagagan community as Name. I believe that's a practice that we adopted during the intervention motion as well. And I want to make very clear that in doing so, I mean no disrespect at all in referring to them
It's
as Name.
possible we were invited to.
I believe counsel for Name-Gusa-Sagagan said that that's a common short form that they use as well. So I may adopt that in my submissions, and I just want to be quite clear. It's done with absolutely no disrespect. And on this point, the group of 7 opposes Name's proposed holdback of 2% to 5% of this court's award, and also opposes the lesser holdback of 1% proposed by Canada. And so in turn,
2 to 5.
I believe in Name's submissions that they presented, they asked for a holdback in the range of 2% to 5%.
Thank you.
Somewhere in that range. And our first point is that the proposal is inconsistent with the terms of Name's intervention order in this case. And we've included the intervention order at page 189 of our oral compendium. Sorry, the intervention order is at tab 41. It starts at page 186, but the relevant provisions are at page 189 of the compendium. And that's specifically terms 2O, 2P, and 2Q. And the terms of this court's intervention order stated that Name was not entitled to make submissions inconsistent with the distribution formula that was agreed to by the group of 5 and the group of 7.
Can you remind me, was this order made on consent?
It was not. The intervention of the group of 7 was on consent. Name's intervention was contested. And specifically, one of the issues issues that was raised by the plaintiffs, Red Rock and White Sand. The group of 7 did not participate in that hearing. We were there, but we had not obtained intervention status at that point. So we did not make submissions on the intervention of Name. But the primary issues that were raised by counsel for Red Rock and White Sand on the intervention order were precisely the issues that granting intervention to Name would import into this case various issues regarding Name's status, including its status, its membership, and it would raise complicated issues regarding the distribution formula, raise issues for this court that weren't properly within the confines of this case. And that's how the intervention order arose, and the terms at OP and 2O, P, and Q of the order to attempt to address these very issues. And so
I now recall that on that motion, there was quite a bit of time on population numbers.
Precisely.
Got it. On population numbers.
And so the intervention order also noted that members of Name could raise distribution issues within the bands to which they are currently registered. There was evidence on the intervention motion about Name members being registered with other RST bands at the moment and other non-RST bands as well. And that Name was not entitled to raise any issues in this proceeding that are properly to be dealt with in other proceedings. And we would submit that issues such as the proper membership of Name are not issues that should be dealt with in this proceeding. And
But
so,
do you say that these are issues in the other proceedings?
there are potentially issues in Name's other proceedings. I believe NAME has ongoing proceedings for band recognition under section 17 of the Indian Act, I believe is the context of those other proceedings. I am not an expert on those proceedings and precisely what is an issue, what is not an issue, but
Proceedings are on hold, is that correct, while they negotiate?
I'm not positive on the exact status. I imagine that counsel for NAME can address the exact status of those proceedings when they discuss the issue. But I believe there were court proceedings. I believe there were negotiations going on. I can't speak to the exact status.
So part of this submission you are making now is a submission in opposition to not only making these submissions themselves in this hearing.
It's
Is that correct?
It's both to NAME making the submissions in this hearing, and it's also on the substance of NAME's submission as well in favor of a 2% and a 5% holdback.
And do I understand that Mr. Schachter's submissions were the same, that he was opposed to NAME being permitted to make submissions that were consistent with their written submissions on this point? On this point that you say is contradictory or contravenes paragraphs 2 sub Q?
Yes, those
Yes.
are Mr. Schachter's submissions.
Okay.
And my further point, the related point, is that NAME's proposal for its 2% to 5% holdback raises the exact problems that this court sought to avoid in granting NAME leave to intervene and in crafting the terms of the intervention order. And that is because it forces this court, either now or on NAME's proposed post-decision motions, to address and decide issues surrounding its status and its membership or its size.
And do you say that had the plaintiffs in the group of 7 aligned with Canada on the 1%, that these submissions could then have been welcome or no? I don't need an answer to that question. That's not what troubles me.
So I will point out that in fairness, clause R, 2R of the intervention order provides the defendants with the right to take any position on allocation or net global award that they wish. So Canada is certainly within its rights to propose the 1% holdback. They're certainly permitted to do so. And term R also says that which position any party adverse in interest has the right to dispute. So perhaps a reading of the term is that NAME would be entitled to dispute Canada's 1% holdback. Mr. Schachter has pointed out to me that in clause R, the parties is a defined term, which does not include NAME. So NAME, I would have been incorrect in saying that NAME would have been entitled to dispute dispute Canada's position.
Where is parties? Is it in paragraph 1?
In the opening words. Top of page 187 in the oral compendium. In any event, regardless of the procedural issues regarding NAME submissions,
I'm just reading at the top of page 187. It reads, on reading the motion materials of the intervener and on hearing submissions from counsel for the intervener, the original plaintiffs and the defendants. Oh, I see. Sorry. I see the parentheses. The original plaintiffs and the defendants herein after collectively referred to as the parties. Thank you. Thank you.
and regardless, we don't rest our arguments solely on procedural issues, but also on the substantive point that NAME submissions for its holdback raise precisely the issues that this court sought to avoid in the intervention order on the substance. And so it will embroil this court in issues regarding NAME status, its size, its proper membership. And those are issues that should not be decided in the context of this case. Again, that's whether you're being asked to decide them now or being asked to decide them on some post-decision motion. This case is not the appropriate forum.
I presume NAME would say, well, don't trouble yourself, courts. Don't trouble yourself with figuring out size, status, membership. Just put the money aside. We'll work that out. And if and when there is a decision on those issues, there will be money available to satisfy NAME's interests. And should those issues be decided in a way that does not require any money, that money will then be distributed as per the original distribution agreement.
And the first issue with that is that even to decide the size of the holdback that NAME is proposing, this court will be drawn into questions of the appropriate potential size of NAME. Those are the issues that it has raised in its submissions in arguing for a 2% to 5% holdback.
I was just pointing out that I presume the argument is it's not a final determination on those monies.
No, it wouldn't be a final determination. And even if the money is held back for NAME, there would be the potential that it could be dispersed to others, or a percentage of it would be dispersed to others once the size of NAME is finally established.
You're saying that the plaintiffs in the group of 7 give up any control of that money once it's held back and or are dragged into a fight on those issues at a later time.
That's right. And there are a number of other issues raised as well that I wish to get to as well with the holdback. And the first is that regarding the size of the holdback, there's no evidence in the court to support the size of the holdback that NAME has asked for. It adduced no evidence in the trial regarding its size or membership. It relies to some extent on its evidence from the intervention motion, which is untested evidence, as Mr. Schachter pointed out. There was no cross-examination conducted on it. And given the terms of the intervention order and the landscape in which we thought we were proceeding on, none of the plaintiff parties sought to lead contrary evidence. At least directly, there is some population evidence before you from Dr. Bignami, from Dr. Driven. could potentially be relevant, but certainly the plaintiffs, the group of 7, did not foresee Name's size as being a live issue in the trial that they would lead evidence on. And even accepting the evidence from the intervention motion, there is nothing that would allow this court to decide that Name's numbers would entitle it to potentially 5% of any award for past compensation, which is the high end of what they ask for. NAME has submitted that its actual membership, when it receives band status, if and when it receives band status, may end up being quite larger than the numbers that it submitted to this court. But of course, there's no evidence in the record to support that.
When submitted to this court on the motion.
On the motion for intervention, that's correct. And for context, I would note that the amount of NAME's proposed holdback with the high end of 5% is greater than the share for many of the members of the group of 7. And I would also note in this regard that Canada has adduced no evidence to support the 1% holdback that it proposes. There's no evidence on the trial proper to support it. The best that I understand Canada is able to do is point to the untested evidence from the intervention motion. Another issue, and this is the central difference between the contingent interest of the group of 7 and NAME's contingent interest, is that there are actually no ongoing extant proceedings that will establish whether or not NAME is an RST beneficiary.
So how did I misunderstand that? Did I understand that their proceedings had been initiated, but they were on pause because there were negotiations?
So there are ongoing proceedings that NAME is involved with. Those proceedings are for band recognition status under Section 17 of the Indian Act. There is not jurisdiction within those proceedings to declare that NAME is a beneficiary of the Robinson Superior Treaty. Those proceedings may well result in a declaration or a recognition of NAME's band status. It will not result in a declaration that NAME is a member of the RST. As I understand it, their proceedings, it was a claim for mandamus to have the minister recognize their band status under Section 17. The minister cannot simply declare that NAME is a member of the RST, and certainly not within the context of those proceedings. And so that raises the issue of it becomes unclear how NAME would become entitled to eventually claim the holdback it's asking for, other than litigating its status under the treaty within the context of this case. Coming back to this case on a post-judgment motion and saying we want our holdback dispersed to us because we are an RST beneficiary, and we're now going to prove that before this court. And that's precisely what it's prohibited from doing under the intervention order.
Let me see if I've got that last point. You would say that if they were successful and obtained their mandamus and a declaration that they have ban status, they would then come to this proceeding to claim RST beneficiary status?
Potentially, that's one potential route.
Where's another route? Or is there another route?
I'm potentially initiating another claim for RST annuities, or another claim in another case for a declaration that they're an RST band. I'm not entirely sure, but certainly by the terms of the intervention order, they're prohibited from doing so within the four corners of this case. And we say that's what sets them apart from the group of seven in terms of their contingent interests. The group of seven has ongoing proceedings, the result of which, one way or another, will determine whether the group of seven are members of the Robinson Superior Treaty.
Thank you.
My next point is that the holdback creates unnecessary complications, and it will force this court to become embroiled in complex questions. And I can think of one obvious example of what might arise, which is assume that a part of the judgment of the award is dispersed to a current RST band, as would be expected. So as the plaintiffs, the group of five, are asking for, let's assume that White Sand receives its share of any award from this court. White Sand then uses the money that was properly dispersed to them for the benefit of its band members. Some of those band members later transfer their membership to NAME. They say, we don't want to be White Sand members, we want to be NAME members, possibly. Does White Sand then get to come to the court and claim a portion of the holdback for NAME? And say, well, we dispersed some of our money that benefited members who are now NAME members. So to avoid double recovery for those members who have now left White Sand, we would like a portion of NAME's holdback. And I'm not asking the court to decide what would happen on such a motion at this point, but I'm simply raising it as a foreseeable issue and complex question that may well arise from the holdback. And the final point that I wish to make, which I think is important, is that Canada can address the issue of proper compensation for NAME elsewhere. And if Canada is of the view that money should be set aside for NAME, it is up to Canada to deal with that issue and could be addressed elsewhere, such as in negotiations with NAME. And as I understand it, NAME's claim is that the issues that have arisen have resulted from Canada's wrongful conduct. Canada's wrongful conduct in refusing to recognize them as a proper band, and Canada's wrongful conduct in registering its proper members with other bands. If they are correct in those submissions, if they're able to establish those claims, then it makes sense for Canada to bear the costs of that wrongful conduct in order to make NAME whole. And we submit that that's the appropriate manner with which to deal with these issues. I do only have about 5 more minutes to go, but I note that I have gone later than the time that we normally break. I'm happy to just finish or come back and make my final 5 or so minutes of submissions after the break.
Let me check. Okay, we're good.
Okay. So the last point that I wanted to address is to just make a few brief comments about Ontario's request that release of this court's judgment should be delayed until after the Supreme Court's decision. And we submit that there's no reason for this court to delay its decision. Ontario is essentially asking for this court to do indirectly what it could not get directly. As this court will recall, the Supreme Court refused to stay these proceedings pending its decision. This court dismissed Ontario's motion to adjourn the case pending the Supreme Court decision. And so it has already been decided that this case can and should go forward. This court is properly seized of the matter, and it should proceed through the normal course and release its judgment in the normal course.
I don't have that decision before me, but didn't I say at some point I'll hear arguments on a delay, or Ontario can bring arguments for a delay?
So I don't think I have the decision before me either, but I did look at it recently. I don't recall that section. What I do recall, Your Honor, mentioning is in the event that the Supreme Court decision does come out prior to the release of your decision in the normal course, it would be appropriate for the parties to be invited to make additional submissions at that point as to how the Supreme Court decision would impact upon your decision. That's, you know, if in the time that it takes for Your Honor to render her decision on the regular reserve process, the Supreme Court decision comes out, we would ask for the opportunity to make additional submissions on how the Supreme Court decision impacts this case. I imagine my friends would as well.
Okay, thank you.
But that's different than saying, you know, pens down until the Supreme Court decision comes out.
I'm going to ask a question of Ontario, who proposes this, and I will ask you now to respond to it if you wish. What mischief could not be corrected on appeal that could be achieved, that could be corrected by waiting? I mean, my question is, isn't an appeal from this decision, should it come before the Supreme Court's decision, isn't that where any problems can be solved, can and should be solved?
It is, and they could. That would be our, I mean, certainly I don't want to encourage any party to appeal the decision, but that is a forum that could resolve those issues.
And you don't, so do you see anything that could not be addressed on appeal? Like does
we don't
waiting simply for the right to appeal leave any issues without a forum to be addressed?
We don't. And on the other side of the ledger, there is great mischief, to use Your Honor's term, that could be caused, and that is the value of an expeditious determination of this case. And in your endorsement on the adjournment motion, you already discussed extensively the value to reconciliation and substantive justice for the plaintiffs in having this trial reach an expeditious conclusion. The plaintiffs have already lived through 170 plus years of an injustice that brings dishonor to the crown. And the evidence from the stage 3 trial has only served to highlight that fact, including the evidence that you heard regarding the suffering of these communities, that the suffering that they have endured while waiting for justice. And so we submit respectfully, the plaintiffs have waited long enough for the Crown to act honorably, and this court should not make them unnecessarily wait even longer. And no one in this courtroom should be responsible for even one additional day of unnecessary delay. And in closing my submissions, I wish to return to the words of the Court of Appeal in this case, quoting the Supreme Court of Canada from Haida Nation. The controlling question in all situations is what is required to maintain the honor of the Crown and to effect reconciliation between the Crown and the Aboriginal peoples with respect to the interests at stake. The question before this court in determining just and fair compensation should be what is required to restore the honor of the Crown and effect reconciliation. In our submission, the answer is an award that gives effect to the common intention of the parties in agreeing to the augmentation clause, including the views, expectations, and perspectives of the Anishinaabe signatories, an award that accounts for the fact that in the past 170 years, the Crown has diverted the benefits from the territory to the non-Indigenous population, while the Anishinaabe have suffered great deprivations, inconsistent with the promise that was made in 1850. And it is an award that properly compensates the Anishinaabe beneficiaries for the lost opportunity to have used the augmented annuities that were due to them to advance the interests of their communities through spending on infrastructure, healthcare, education, and other social investments. These communities would look very different today had the Crown kept its promise in the last 170 years. And we can't know what they would look like had the promise been kept. And we can't turn back time and reverse the damage that has been done. What we can do is do our best to justly compensate them for their lost opportunities and to ensure that the future unfolds differently. And that is what we're asking this court to do. Barring any further questions, those are the submissions on behalf of the group of 7.
Thank you very much.
Thank you.
I'll just catch up and we'll take a break.
Before we do, I just wanted to get back to the issue of whether NAMA's counsel is making submissions before or after mine. I can't recall how we resolved that or whether we did resolve that.
Yeah, it was after.
Okay, after. Okay, thank you.
Thank you. Is Mr. Greenberg signed in today? Thank you. All right, let's take the morning break. Canada, you'll be moving to the podium. All right, noon, does that suit? Thank you.
Order, all right.
This court is stood down for 15 minutes.
All right.
Court is resumed. Please be seated.
Ms. Evans.
Good afternoon, Justice Hennessy. Much as I would like to dive right in and respond to my friend's submissions that he just completed, we have to instead go right back to the beginning. So I'm going to start with outlining Canada's approach, making sure you have Canada's materials, and outlining the order of submissions that we intend to follow. And eventually, I'm hoping I will get around to responding to each of the arguments you've heard from my friends this morning. So first, a matter of the materials you should have. We don't have a complete compendium, Justice Hennessy, and that's partly because, of course, our submissions are in response, so we have to be responsive to what we've heard. There are also some technical glitches operating up here in Thunder Bay where the printing services don't operate as quickly as might be ideal. So what you should have is our hyperlinked written submissions. And it's quite possible that as we refer to documents, I'll suggest to you that you click on the link in our written submissions and you'll be able to find them there. And of course, my colleague, Ms. Sang, will be bringing them up on the screen as well. So that said, though, we have sent to our friends just a very basic outline of the order of the submissions we intend to follow. And with this portable printer, I did print one copy for your honor, so I'll bring that up.
Thank you very much.
I had intended to send this outline to all of my friends, but I understand that my colleague is having computer problems right now. So it may take a moment, but we will send it to everyone. First, I'd like to start off by saying that the written submissions that you have, both the main submissions and reply from Canada, reflect a true team effort. And I really do want to acknowledge my gratefulness to my colleagues for helping me with them. I hope you find them helpful. In addition to Mr. Fisk and Ms. Sang, of course, Ms. Crew and Ms. McNamara helped, as did Elizabeth Chan in Toronto. I'd also like to acknowledge that our paralegals did all of the hyperlinking of the written submissions, which is a monumental task when we had over 700 footnotes between the two sets. So I want to thank them as well. And I hope you find the hyperlinks helpful.
Thank you, I do.
So the outline that I provided to you and that I hope my friends have shortly, I've just explained where we intend to go so you know what to anticipate. The first topic that I will be addressing is situating the duties and the breaches. And to do that, I will be using the reasons of this court in stage 1 and the Court of Appeal, the treaty, the judgment, and perhaps one case. After situating the duties and the breaches, and the purpose for doing that is in order to understand the remedies available, we first need to understand what were the duties and what were the breaches. After situating that, I'm going to do an overview of Canada's positions on the main topics. And then we'll be addressing each of those topics in turn. The first topic that I will be addressing is Crown allocation. And I think I explained to you earlier, we might have put that at the end, but for a number of reasons, organizational reasons, I'll be dealing with that first. But the other issues that follow the order of our written submissions that we will be addressing are principles of compensation. That's going to be case law heavy, and my colleague Ms. Crew will take us through that. Then net Crown resource revenues. I'll be addressing why it's Canada's position that net Crown resource revenues are the proper measure for the compensation award rather than economic rents. And then my colleague Ms. McNamara will be addressing the issue of spectrum and whether it is captured by the judgment as a resource revenue that must be shared. Then I will return to address present value, share, distribution, which includes the NAMA question, and finally, future implementation. So I'd like to start then with situating the duties and breaches. And as I said To understand the remedies required, we need to understand the duties and the breaches. And the place to start in understanding the duty is the treaty. So the first thing I'd like to turn up is the augmentation clause.
I will not be turning up
That's fine.
your documents on the hyperlink. If you want to bring them up or someone does that, would be great.
So
I'm dealing with enough screens.
understand.
Thank you.
To me, the place that I'm going is the augmentation clause is reproduced in your stage 1 reasons for decision at paragraph 243. So that's where I'm going to look. And I know my colleague, Ms. Sang, will put that up on the screen as well. So much of this, of course, you probably have committed to memory. We've gone through it many times, but what I want to focus on starts with the second line. So Benjamin Robinson, on behalf of Her Majesty, further promises and agrees that in case the territory hereby ceded shall at any future period produce an amount which will enable the government of this province, without incurring loss, to increase the annuity hereby secured to them, then and in that case, the same shall be augmented from time to time. Those are the key words that I want to work with. Her Majesty promises that in case the territory hereby ceded shall at any future period produce an amount which will enable the government, without incurring loss, to increase the annuity, then and in that case, it shall be augmented from time to time. So the rest of the augmentation clause deals with the distributive amount. It refers to this, I'll call it soft cap, that pertains, as we understand, only to the distributive amount. So the first thing I like to say is Canada accepts, of course, the stage 1 findings that the annuity is both a collective and a distributive amount. And really, we're interested here in the collective amount. We accept that it is a mandatory obligation to increase the annuity from time to time if resource-based revenues permit the Crown to do so without incurring loss. There's no cap on this, and it is a treaty right. Your Honor made that clear in the judgment at paragraphs 1A and 1F. This is a treaty right. It's a mandatory obligation. If resource-based revenues permit the Crowns to do so without incurring loss, the annuities must be augmented. So this duty to increase the annuity is corollary to the treaty right. It is not subject to Crown discretion, and Canada accepts that. Now, the distributive amount, we understand to be some portion of the collective amount. Your judgment made that clear in paragraph 1E. And the Crown's graciousness only applies to the distributive amount. And there is, of course, some Crown discretion in implementing that part of the treaty augmentation clause. That was also made clear in your judgment, that the Crown shall consult with the First Nations to determine how the distributed amount or distributive amount shall be augmented. So there's discretion there, but we understand no discretion in the treaty promise, the treaty right to augmented annuities if resource revenues permit. But there's another duty. And when you look at the words of the treaty, you may not see it right away. But the other duty is the duty to engage in a process. So for that duty, we need to look not at the treaty, but at the judgment. And here I'm pulling up the judgment that is at the end of the Court of Appeals decision, and I'm sure my friend, thank you, my colleague, Ms. Sang, has put it up on the board. So in the judgment we see at paragraph 1B, well, first paragraph 1 says, this court adjudges and declares that A says, the Crown is obligated to increase and the First Nation treaty parties have a collective treaty right. to have the annuities increased. And then 1B speaks about to fulfill its obligation in A above, the Crown is required to periodically engage in a process in consultation with the First Nations to determine the amount of net Crown resource revenues. There's a further duty to engage in a process or consult that's specified in the judgment, and that is at 1E, where it says the Crown shall, in a manner consistent with the honor of the Crown, consult with the First Nation treaty parties to determine what portion, if any, of the collective amount that is to be distributed to individuals. So in the judgment, we see two specific duties to engage. The first one is to consult with the First Nations to determine the amount of net Crown resource revenues. The second is to consult with the First Nations to determine what portion of the collective annuity should be distributed to individuals. And these duties are not specified in the treaty, but the court has found, and Canada accepts, that they are required elements of the duty of diligent treaty implementation. And we also note paragraph 2B of the judgment, which we've read many times in court already. This is the part that focuses on your finding that the common intention was to allow both communities to realize the future opportunities and potential of the treaty territory in a manner consistent with the Anishinaabe principles that we've spoke of: respect, responsibility, reciprocity, and renewal. And of course, with the Crown's intention to act liberally and with benevolence. So we understand that part of the judgment is also important in defining or helping to identify what is a required element of the duty of diligent treaty implementation. So what we're talking about is a duty of diligent treaty implementation when we're talking specifically about this duty to engage in a process. This is the way that the duty was described by the Ontario Court of Appeal in its decision. Just for reference, I'll tell you, it's the heading that they use in their reasons before paragraph 231. And this court as well spoke in terms of the duty as one of diligent implementation. And I refer you, for example, to paragraphs 3 and 393 of your decision. The duty to diligently implement a constitutional obligation to Aboriginal peoples, which would include here the treaty promise, flows from the honor of the Crown. And it was articulated in Manitoba Métis, the case that we've already referred to today. And Manitoba Métis decision was quoted by the Ontario Court of Appeal. And I want to take the court to that now. The Ontario Court of Appeals decision on the stage 1 and 2 appeals at paragraph 241. So here the court is talking about the Crown's duty under this treaty. And the Court of Appeal says at the bottom of page 241, first of all, it's defined the duty here as the duty of diligent treaty implementation. And then it says, to fulfill the duty of diligent implementation, and I'm reading at the bottom of, well, actually, it's the middle of 241, the bottom of the page I have. To fulfill the duty of diligent implementation, quote, Crown servants must seek to perform the obligation in a way that pursues the purpose behind the promise, close quote. That's a quote from Manitoba Métis, the Supreme Court's decision. Then implementation need not be perfect, but, quote, a persistent pattern of errors and indifference that substantially frustrates the purposes of a solemn promise may amount to a betrayal of the Crown's duty to act honorably in fulfilling its promise, close quote, also from Manitoba Métis. These are the duties that arise from the honor of the crown in relation to the promises made in the Robinson treaties. And here I'd actually like to pull up Manitoba Métis Federation case directly. I'll ask my colleague, Ms. Sang, to do that. I want to look at paragraph 79. And halfway through the paragraph, it's noted that the duty goes further. If the honor of the crown is pledged to the fulfillment of an obligation, it follows then that the honor of the crown requires the crown to endeavor to ensure its obligations are fulfilled. So Manitoba Métis tells us that the duty of diligent implementation, which flows from the honor of the crown, requires crown servants to seek to perform the obligation in a purposive way and to endeavor to ensure the obligation is fulfilled. Inherent in this is the recognition that implementation need not be perfect. And in fact, the Supreme Court uses that exact terminology in Manitoba Métis. Implementation need not be perfect. Of course, the Supreme Court also tells us that a persistent pattern of errors and indifference that substantially frustrates the purpose of the promise can amount to a breach of the duty to act honorably. But we need to keep in mind that the duty to diligently implement a treaty needs to be flexible. It can't be perfect. It needs to respond to the circumstances. I submit that the duty to augment the annuities when net crown resource revenues permit is a mandatory, non-discretionary duty. But the process to achieve that is flexible. And in fact, the treaty itself suggests flexibility in the implementation of the promise, because the treaty itself says, then and in that case, the same shall be augmented from time to time. And I suggest to you, from time to time means there's going to be flexibility. The judgment also acknowledges this flexibility in the order finding that the Crown is required to periodically engage in a process in consultation with the First Nations. Now, this flexibility and diligent implementation has implications for the remedy, which I will get to. But first, I want to address Mr. Schachter's argument that there is another much broader duty to engage in a process. Mr. Schachter suggests that there is a duty to engage in a process by which the parties would have discussed whether the Crown would capture more of the rents, maybe even whether and how the Crown would exploit the resources. Mr. Schachter characterized this as engaging in the process to determine how big the pie would be. Now, of course, I acknowledge he also made comments saying that he was not suggesting that this court upset the constitutional order. He was not asking for co-management. But frankly, it's difficult to see the distinction when he suggests that this duty of diligent implementation requires the Crown to engage with the First Nations to discuss whether and how to exploit the resources and whether and how to capture more rents. Mr. Schachter also described a duty to engage in a process by which the parties would have discussed what the share would be. And he described this as how much of the pie goes to the Anishinaabe. There are three problems with this argument that attempts to expand the duty to engage beyond the language of the treaty and the judgment. The first is, there was no finding by either court, either this court or the Court of Appeal, that the duty of diligent treaty implementation actually requires these engagement processes. The judgment is clear on the two processes that I outlined in paragraphs 1A and 1F. Mr. Schachter grounded the alleged duty to share, to engage in a process to determine the share. He grounded that in paragraph 3C of the judgment. So I'd like to draw pull that up. In 3C, this court further adjudges and declares that failing agreement amongst the parties, the principles to be applied for purposes of determining amounts to be dispersed pursuant to the augmentation promise from net Crown resource-based revenues are subject to further direction by the court in a future stage of this proceeding. Now, Mr. Schachter invites the court to read this as requiring the Crown to engage in a process with the First Nations to determine the amount to be dispersed. And I think he takes that from the wording failing agreement amongst the parties. I suggest to you, Justice Hennessy, that what is intended here is an aspiration. This is aspirational. It is aspirational that the parties will agree on the principles for determining share. But there is no duty here on the Crown. And there's specifically no duty that the Crown failed to meet in the past for which monetary compensation is required. Speaking on the issue of share, I note that when this court and the Ontario Court of Appeal spoke of the parties returning to the shared goals, expectations, and understandings of the parties in 1850 to devise processes and procedures for the implementation of the treaty promise, this as well was spoken in aspirational terms for the future. So I'd like to take a look at, for example, Ontario Court of Appeal, paragraph 323. This is a paragraph my friends have read to you as well. It starts with a quote from your own decision, Justice Hennessy. The trial judge noted, here we have the court and the parties must return to the shared goals and expectations and devise processes and procedures for the implementation of the treaty's promise in the modern era. And the Court of Appeal goes on to say the parties in negotiations or the trial judge in stage 3.
It's a problem that happens when one reads. It's usually a faster pace than just speaking.
The parties in negotiations or the trial judge in stage 3 must determine the form, level, and aim of the sharing. And at page 324, the remaining task of interpretation and the basis of implementation lies in determining what the sharing relationship envisioned by the Anishinaabe and the Crown in 1850 would look like today, and how that relationship can be brought about. Remember that the duty of diligent implementation flows from the honor of the Crown. It does not require perfection. Implementation is a process which will have to be responsive to the particular circumstances. There is no right way to implement for all time. This court found in the stage 1 reasons for decision that the Crown retains significant discretion in the implementation process. And I'll come back to that shortly. But I was addressing Mr. Schachter's argument that there's an expanded duty here. And I said I had 3 arguments. The first is it's not actually set out in the judgment or in the reasons of this court or the Court of Appeal that there are these duties. The second argument I have is that there is no evidence that engagement in a process to discuss the capture of resource rents or the exploitation of the resources would have actually led to a bigger pie. There's no evidence of that. It's speculation. And in fact, we could just as easily speculate the other way. And there is some evidence, at least from Chief Machano, for example, that the Crown's resource development had caused environmental devastation. So I suggest to you there are no grounds to assume that engagement with First Nations would have produced a bigger pie. Finally, and this is my third point, my third argument.
I believe when I put that proposition to Mr. Schachter, he said he wasn't necessarily talking about, or he wasn't talking about cutting more trees. He was talking about the economics of creating the pie, if I have that right.
I understand that, but again, there's no evidence. There's no evidence that the First Nations would have actually would have required or required the Crown to increase or proposed methods for how the Crown might increase the capture of resource rents. Of course, there's all kinds of other reasons why we say resource rents isn't the right method. And the main point here being, we don't agree that the duty of diligent treaty implementation requires this level of consultation. But my last argument, my third argument on this point is Mr. Schachter suggests that the onus is reversed and the defendants must prove that engagement would not have led to a bigger pie. He claims there's a presumption at common law that if the defendants had prevented the plaintiff from knowing the true scope of the loss, then the measure of damages is the one most favorable to the plaintiff. This is not, in fact, the law, and my colleague Ms. Crew will address this when she deals with the case law. But I want to return to Canada's discretion. I mentioned earlier that within the duty of diligent treaty implementation, there is room for flexibility. We know from Manitoba Métis, it doesn't need to be perfect. We know that the Crown must seek and endeavor to do its best to diligently implement the treaty. So there's flexibility in the duty of diligent treaty implementation. There's flexibility in this treaty itself when we talk about from time to time, and in the judgment, periodically engaging in a process. And in the reasons for judgment, it's acknowledged that the Crown retains significant discretion in the implementation process. Now, the courts have found, and Canada acknowledges, that this discretion is not unfettered. It must be exercised honorably, and it is subject to review of the courts. It is justiciable. The Court of Appeal told us that. Canada says it's justiciable against the standard of the honor of the Crown. We're not talking about judicial review at administrative law. There's procedural reasons why that wouldn't even be appropriate. Canada submits that if the parties can't agree, then the Crown can exercise its discretion, and then the First Nations are entitled to challenge whether the Crown has diligently implemented the treaty promise. But again, the starting point is the Crown has just significant discretion in the implementation process. And so for that, I want to look at the stage one reasons, paragraph 568. The honor of the Crown requires that the Crown work diligently to implement a process to consider increasing the annuities and the economic factors that interact with that decision. Should the net Crown resource revenues, as ultimately defined or agreed on, permit increases to the annuities to reflect the value of the ceded interest, the Crown does not have unfettered discretion on whether or how to make increases to the annuities. Nonetheless, the Crown does maintain significant discretion under the treaties, including the implementation process. That paragraph goes on to emphasize the importance of disclosure and really frames a significant part of that duty of diligent implementation to require adequate, proper, sufficient disclosure to enable the First Nations and eventually, if necessary, the court to assess really the accuracy of the Crown's numbers on net Crown resource revenues. The Ontario Court of Appeal agreed with the significant discretion point. For example, in paragraph 77, they note the significant discretion. So now that I've situated the treaty promise and the judgment and the scope of this duty of diligent implementation, I want to talk about the breaches and the remedies. So here we have two duties: the mandatory obligation to increase the collective annuity if net Crown resource revenues permit. And the second is the duty to engage in a process. There's two aspects to that: the duty to determine the amount of net Crown resource revenues with an emphasis on sufficient disclosure to enable the First Nations to determine the amount, and the duty to engage in a process to consult with the First Nations about which portion of the annuity should be paid to individuals. So these are the duties.
Do you say those are three then? Mandatory obligation to increase the collective annuity. If NCRRs permit. Second, a duty to engage in a process.
You could look at it as three. I myself have conceptualized it as, 2A and B.
Oh, okay.
One is the mandatory obligation to increase. Two is the duty to engage, A, in determining the amount of net Crown resource revenues, B, in determining what share may be distributed to individuals. But you could look at it as three.
Okay, thank you.
So first I want to talk about the first duty, the mandatory obligation. Canada admits that economic circumstances did permit augmentation of the annuities, but that these were Ontario's revenues and Ontario had the duty to share them. Canada does not admit specific amounts in specific years. This is because Canada does not have the required knowledge of Ontario's revenues and expenses in order to take a specific position on years and specific amounts. Canada is in no better position than this court is to determine from the evidence presented by Ontario and the plaintiffs on the actual revenues. But we do know it's not a straightforward issue. It's subject to primarily really what you consider to be appropriate expenses. So Canada doesn't accept either the plaintiffs or Ontario's calculations on net Crown resource revenues. But we do acknowledge that some net Crown resource revenues were realized. Exactly what they were, I'm not going to take a position on, Justice Hennessy. I'm going to say some of them were realized. There's at least enough evidence to know revenues were realized. The issue is really what are the appropriate expenses to take into consideration. So Canada is proposing.
Did you say earlier that the issue is expenses?
Yes. And I think that's, I can pull it up, it's certainly in our written submissions, that generally speaking, Professors Smart and Bodway agreed with Mr. Hutchings, really, on the basic revenues. There's relatively little difference in their views on revenues. The differences really were on expenses. So Canada readily admits we're proposing a compromise position that we believe is reasonable. And that is, the truth lies somewhere in between. Canada is not saying cut it right down the middle. Because if you take, and in order to compare apples to apples, you need to look at present value numbers. So if you were to take, and I'll get into this in more detail later, but if you take the present value of net Crown resource revenues as estimated by Mr. Hutchings at about 8.9 billion, and is estimated by Professor Smart and Bodway as about negative 4.6 billion. If you were just to saw it off in the middle, you'd arrive at 2.16 billion. And that's in our written submissions at paragraph 12. It's just math. But Canada, in its submissions, is suggesting an amount that would be closer to the plaintiffs' estimate of NCRR than to Ontario's. And that is in recognition of the fact that the plaintiffs have made criticisms that suggest that Professors Smart and Bodway were over-inclusive of expenses. Canada is prepared to acknowledge that criticism and therefore is proposing that the court use an estimate of net crown resource revenues that's really closer to the plaintiff's number than Ontario's number. And we've calculated for you and set out in our written submissions, if you were to take the difference between the two and move the needle 2/3 the way to the plaintiff's numbers, you'd have 4.4 billion.
But you're doing that on present values.
That's right. Because
Knowing that a huge part of present value is also a debate.
yes,
So
but
wouldn't it be helpful if you did it on nominal values? And then left the question of present values as a separate question?
in my submission, you can't compare nominal values. And I think Professor Smart and Bodway said the same thing. You can't compare those nominal values because you know, they don't mean that much when you know the nominal value is, let's say, 1 billion, when the portion that was earned back in 1850 may be $24, and the portion that was earned most recently may be $24 million. So it's not really fair and accurate to treat all those numbers as the same. We need
as a first step, when you're setting up, you're looking at both. So you say the present value as per Mr. Hutchings is 8.9 billion, and as per Bodway is minus 4.6. So you are setting up a comparison, and you clearly say that's the present value comparison. And I just wonder, given that the how to bring forward nominal values is the subject of a distinct debate, whether you say anything about nominal values. You started out by saying a nominal, perhaps you were saying on nominal values, say we're in no better position than the court. It's all over the map or something like that, and there's a big issue on expenses.
I'm just looking to find I'll ask for your indulgence while I find my friend's compendium, because there's some materials in there that I want to refer to, and I'm just taking a moment here to find that. So Professor Smart and Bodway did not calculate there we go. I'm mistaken about that. So if you're looking at the gross nominal direct revenues, and I'm looking at, I don't know if my colleague can pull it up, page 15 of my friend's compendium, Stiglitz and Hutchings estimated that as the figure we've heard many times, 1.043. And Professor Smart and Bodway estimated it as negative 1.6. But part of the problem, Justice Hennessy, is if we were to...
Sorry, this is nominal values, 1.043.
Yes.
Thank you.
For Stiglitz and Hutchings, and negative 1.6 for Smart and Bodway. But part of the problem is if you were to say, let's take these numbers and find a range in between the two of them, and then bring that forward. Here's the problem. Who is going to bring it forward? The bring forward calculation is incredibly complex. And that's a submission I'm going to get into. It's not something that any of my colleagues, or I submit anybody in this courtroom, can do. Because to properly assess present value, you need to know the exact figure of revenues or rents in each year, and then the interest rate or rate of return you apply varies in every year. So it's a complex calculation, and it was not done by any of the experts here. So in my submission, I mean, what I'm saying is not what was not done. Certainly they took figures they could agree on that were submitted in their respective reports. But if this court or these parties come up with new figures, we've got to go back to the experts. Thank you.
You're saying we can't do it now if there's a new number for nominal values.
Yeah. So it's more helpful than, let's look at the numbers we do have. Because it is
not that no one can assess present value. It's no one can calculate present value on a new nominal value amount.
That's right. And I'm not saying it's not possible if we were to stand down the trial and go and ask the experts, can you please recalculate this with these new numbers? But the problem with that is,
You're saying it's not divorce mate.
it's not just plug in the numbers. And of course, you know, that we run into this problem when you see any decision the court makes on, hey, I'm not going to include these types of forestry expenses, has quite frankly unknown implications on the final numbers, because we would need to go back to the experts and say, take out forest expenses, you know, and each year it's going to be different. That means each bring forward is going to be different, of course, because it's compounded, it makes a difference. So that's why Canada has used the present value numbers. And also, it's really only Smart and Bodway that calculated the present value. They're the ones that have the numbers on that allow us to do a direct comparison between the Smart Bodway approach and the Stiglitz-Hutchings approach on the bond, using the bond rate. We don't have those same figures, if I recall correctly, for the BTA rate, for example. So in any event, I'm going to get into more detail about that, of course, when I do submissions on net crown resource revenues. But the point that I'm making here is that the remedy for this is a breach of the duty to augment the annuities when resource revenues permitted. Canada is acknowledging and accepting the plaintiff's evidence that there were net crown resource revenues. We're not saying exactly what they are, but we're accepting that the plaintiff's evidence, there were some, meaning annuities should have been augmented, and we're suggesting to determine the amount of past compensation due, let's assume that the net crown resource revenues were $4.5 to $5.5 billion as expressed in present value. Now, of course, there are other reasons I'll get to as to why we believe this bond rate is an appropriate rate to use to assess present value. But I was talking about remedies for the duties and the breaches, and we've talked now about the mandatory duty to augment the annuities, which requires Canada's admission that there in fact were net resource revenues. So the second duty, which I've separated into A and B, is this duty to engage. Canada admits that it failed to engage in a process with the First Nations to determine if annuity increases were permitted without incurring loss. That is, to determine the amount of net crown resource revenues. Canada admits that breach, Justice Hennessy. We've admitted it in writing in our submissions in paragraphs 29, 430, and 432. Canada submits that the remedy for this breach is that a declaration would be an appropriate remedy for this breach. Because the failure to engage in a process to determine net crown resource revenues, and in fact to determine if augmentations were permitted, is being compensated for by the time value of money. The failure to engage resulted in a delay. It resulted in inactivity and in a delay in the plaintiffs receiving their augmented annuities. And I will explain to you, Justice Hennessy, why, in our view, compound interest addresses this delay. Compound interest addresses the time value of money. And the breach of this particular duty to engage in a process to determine net crown revenues, resource revenues, does not require an additional monetary award of compensation. And again, we're talking about a duty to share information with the First Nations about net crown resource revenues. We looked at how the duty involves consulting to determine the amount, including disclosure. The duty of diligent implementation includes the disclosure. This is the duty we're talking about. We're not talking about Mr. Schachter's expanded idea of a duty to actually negotiate with the First Nations about how to capture resource rents. I've already submitted that wasn't part of the duty. That's not part of the duty of diligent implementation. And remember as well, the duty of diligent implementation has to be flexible and change with circumstances. So the fact that it was not a duty in the past doesn't mean it may not become a duty in the future in the right circumstances. So furthermore, the failure to engage in a process, as I was saying, to determine how resources should have been collected is not compensable because A, it wasn't part of the duty of diligent treaty implementation, as found by this court. Furthermore, as I mentioned earlier, there's actually no evidence of loss resulting from such a failure. And finally, even if, Justice Hennessy, you were to find that in fact, the duty of diligent implementation required that the Crown engage with the First Nations in a process to determine how the resources should have been exploited or how the rents should have been collected, Canada has no part in that process, Justice Hennessy. These resources are Ontario's. Now, Canada concedes that if it had revenues, and we will argue that it didn't, but if it did, that Canada would have an obligation to share that information with the First Nations. And in fact, Canada has shared all of the information it has about spectrum revenues. But Canada does concede that the breach of the duty to engage in a process to determine net Crown resource revenues, both Crowns are responsible for undertaking that duty. As I said, if Crown were to have revenues, if Canada were to have revenues, it's Canada's obligation to share that information with the First Nations. And furthermore, Canada accepts that it might have supported the First Nations in getting Ontario to the table. So Canada's failure to engage with the First Nations to determine net Crown resource revenues, Canada accepts that it might have caused a delay in the First Nations realizing a share of Ontario's resource revenues. And Canada acknowledges that responsibility.
Let me see if I understand what you're saying. You say, had Canada fulfilled the duty to engage at some point, I'm not sure when you're saying that, Canada might have supported the treaty beneficiaries in getting Ontario to the table.
Yes, yeah, that's right. What I'm saying is, I'm acknowledging that when Your Honor made this, the judgment that the Crown has a duty to engage with the First Nations to determine net Crown resource revenues, Canada's not saying, that's not our job, that's Ontario's, we'll back away. Canada's accepting. Canada has the duty to diligently implement the treaty. And if that requires, as the court has found, an engagement with the First Nations to share information about net Crown resource revenues, Canada accepts that it has that duty, and it had that duty in the past. Canada accepts that it, for example, we can't say for certain. This is why really declaratory relief is better here. We can't say for certain that Canada could have, I don't want to use the word force, but it could have forced Ontario to share revenues. We're not saying Canada would have necessarily had that power, but we do acknowledge that Canada should have engaged in a process with the First Nations to say, hey, it's time to sit down and look, in order to implement this treaty promise, it's time to sit down and look at what the resource revenues were. Of course, the vast majority, if not all of them, are Ontario's. So why I'm getting there, Justice Hennessy, is because Canada does propose in our submissions that you make a finding of liability against Canada for 15 to 20% of the entire award. And the basis for that argument, for that admission, Justice Hennessy, is we recognize that it's possible that Canada did not engage with the First Nations in a process to determine NCR, and there's got to be a remedy for that. Declaratory relief might be a sufficient remedy, but Canada's going beyond and saying, you know what, we realize that our inactivity may have contributed to the delay in you receiving your compensation. And as an expression of our responsibility, we're proposing 15 to 20%.
I thought you said a moment ago that there's no additional monetary compensation for breach of the duty to engage.
Yes, I did. And I know that my submissions seem contradictory. And what I'm trying to express here is Canada is attempting to take its responsibilities toward reconciliation at heart. We're not going to walk away and say we owe nothing to the First Nations. But we are going to place Canada's responsibility in context. And I do acknowledge, really, the First Nations aren't going to get any more money if Canada pays 15 to 20% of the award. It's still the same award that the First Nations are going to get. So really, in effect, you may consider this to be Canada subsidizing Ontario. You may look at it that way. But even if that is the way you look at it, it's intended as an acknowledgement of Canada's responsibility and the fact that Canada may have contributed to the delay in the realization of compensation for the First Nations.
I'm just looking at the clock. Is this a good time to break?
Yes, it is. I'm sorry I don't have a clock right in front of me. So
You have friends.
all I'm doing is looking at you.
Everybody's got their job. All right, we'll take a break. 2:15, would that suit everyone? All right, thank you.
Court is stood down until 2:15.